All rise. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court from recess now sitting.
Please be seated. Good morning. Ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the final case on this week's docket.
Thank you, Your Honor. May it please the court. The 10:30 a.m. docket for Friday, March 31st, 2023 consists of one case. Appeal number 123063, Kansas Fire and Safety Equipment, a Kansas corporation, Hal G. Richardson doing business as Bueno Food Brand, Topeka Vinyl Top, and Minuteman Solar Film versus the City of Topeka, Kansas, Shawnee County, briefs both sides.
It please the court, John Hamilton and Jason Pryor are appearing on behalf of the appellants. And I am ready for the argument. And I'd like to reserve 3 minutes of my time for rebuttal and to respond to the appellees cross appeal. Sorry.
3 minutes is granted.
May it please the court, Shelley Starr, Chief of Litigation for the City of Topeka, present and ready for argument.
Your Honor, that concludes the docket for the week of March 27th through 31st, 2023.
Council, you may come forward and take your places at council table and but take your time getting settled and comfortable. But when you are, Mr. Hamilton, you're welcome to come to the podium.
May it please the court. This case has been pending in the district court and had 3 separate appellate reviews over the last 9 years. This court remanded the case during the last time it was before the court, ordering, I quote, further proceedings to explore whether the city's negotiations were in advance of condemnation. These proceedings never occurred. Instead, the city filed another motion for summary judgment, raising for the first time that the court lacked subject matter jurisdiction. The city's motion for summary judgment also realleged the same issues that had been previously decided by the court. The district court and the Court of Appeals erroneously ignored the fact that the primary purpose of the Federal Relocation Property Acquisitions Policies Act, which is the URA, is to ensure that displaced persons shall not suffer disproportionate injuries as a result of programs and projects designed for the benefit of the public as a whole, and to minimize the hardship of displacement of such persons. The Kansas legislature enacted KSA 26518 and 583501 et seq. For the purpose of implementing the URA by requiring Kansas agencies and departments to comply with the provisions when providing relocation payments and assistance. The language in both statutes is basically the same. It is the same as far as it pertains to what is in KSA 26518. URA gives the agency, requires the agency to give 90 days notice that the person will be displaced and describe the right to appeal, which was never done in this case. Legislature provided 2 paths for displaced persons to receive relocation benefits. KSA 58-3501 et seq. Involves an administrative process, and KSA 26518 does not. We elected to proceed under KSA 518. The administrative process is basically where the agency appoints one of its own as the hearing officer and appoints one of his own as the attorney. And of course, you can appeal that based on the record de novo to the district court. The city's argument that the district court, now the Court of Appeals accepted, is based upon a line of cases that have held that you cannot challenge the right to take in the pending eminent domain action. From that, counsel for the city argued and the court accepted that nothing can happen in the eminent domain proceeding under the Eminent Domain Proceeding Act other than vesting title in the condemning authority. Well,
Ask you a question. I'm over.
yes, sir.
Yeah.
I'm sorry.
You sort of summarized for us the two different acts and
Yes.
I'll just call the Eminent Domain Procedures Act, and I just shorthand the Kansas Relocation Act.
Right.
Those two statutory provisions both contain language contemplating relocation benefits for displaced persons. But only one contemplates a right to review before the district court. That a fair summary?
Well, only one, the 583501 gives you the right to review from the agency, but I think the chapter 26, which is the Eminent Domain Procedure Act, specifically provides for direct relief, in my opinion, to the district court.
Just based on the right that is set out under the Eminent Domain Procedure Act for relocation benefits.
Yes,
And it just seems to me, though, that the statutory scheme for under the EDPA and our case law interpreting it has limited judicial review to the question of compensation, which has been determined to be fair market value of the taking itself.
well, the act provides for other relief, such as attorney's fees in the event the condemning authority appeals and they're not successful on the appeal, or if they abandon the project after the appraiser's report's filed. So that's another remedy under the act, and it's there because it's specifically provided in the act.
Right, and the remedy maybe is different from the actual scope of judicial review that's permitted under the act. Would you agree with that? Or at least conceptually, those two concepts differ legally. In other words, a remedy doesn't necessarily mean a right to review.
Well, not sure.
Or is that flawed? I don't know.
I'm not sure I quite understand the question, Your Honor.
Okay, well, you've identified various remedies that the Eminent Domain Procedure Act contemplates, but there's only one statutory provision that discusses judicial review.
I
from the
understand.
district court. Yeah,
That's true.
okay, okay.
Judicial review meaning appeal from the district court.
Correct,
Yes, sir.
correct.
That's correct.
Okay, or even to the district court itself, from the appraiser's report.
From the appraiser's report, that's true.
Okay. Okay. So how would you read the statutory provision under that gives the right to review? What's your theory on why it encompasses benefit determinations?
Well, if you don't have a right to proceed under 26.518, the statute is absolutely meaningless. The legislature put it there for a purpose. And for instance, the Missouri statute, Eminent Domain Procedure Act, does provide for the right to challenge the taking itself because it's in the act. In Kansas, it's not, but this statute is in the act.
So just to kind of launch off where Justice Wall, why, in 26.508, which is the statute to which Justice Wall is referring about the right to review, right? Okay.
Yes, ma'am.
And the very last sentence says, the only issue to be determined therein shall be the compensation required by 26.513. So if we why aren't we limited by that?
Well, legislature saw fit to put this statute in the eminent domain procedure act. And there are two other things I just mentioned you can get relief on in the act.
But can you appeal attorney's fees under this last sentence of 26-508?
I would think you could.
So would that be in direct conflict with our case law that says that we are constricted by the plain language of the statute?
I don't think it's conflict, Your Honor. For instance, say that the district court awarded $1 million attorney's fees in a case that involved 2,000, for instance. Certainly that could be appealed. That wouldn't be the final arbiter of that issue. I think that you can appeal anything that's in the statute that gives a right.
So what does that sentence mean?
Well, it means on the compensation, you can appeal from the appraiser's report to the district court. And if unsatisfied with that due to whatever errors occur during that trial, I think you can appeal directly to the Supreme Court. The Act does say appeals are from the district court or to the Supreme Court.
What does the word compensation mean in 26-508? The only issue to be determined shall be the compensation. So they're saying you're limited to appealing compensation, or actually what it's saying is the court is limited to determining compensation. What's the definition of compensation?
Amount of money awarded by the appraisers. Pardon me. That is the appeal right from the appraiser's report.
Does that word compensation include attorney's fees?
I think that's referring to compensation for the land taken. It enumerates, what, 16 or 17 items, and then goes on to say, these are not all inclusive. So I think that's what that deals with.
Thank you.
Yes, ma'am.
But remind me, this case, I guess you're not reminding me, I remember, but we've got to stay focused on the fact that this landowner who held title to the property settled with the city before condemnation. So title passed to the city in order to project, right?
Correct, sir.
And so your problem is you represent the tenants. So you're trying to get relocation benefits. So how do you fit under any other scheme other than the administrative process to get relocation benefits?
Well, it was put in the eminent domain procedure act for some reason. To provide two different remedies, two avenues where you could get the same remedy. So the tenants could care less whether the owner settled or was condemned, but that's been decided that we have to first prove. Now we have to prove that there's more likely so than not they would have condemned, and these tenant was displaced 9 years ago, and the whole idea of the statute is to give the tenant fair compensation for being relocated. If in fact we can prove that they would have condemned had the negotiations been unsuccessful. And in that regard, I think haven't rehashed all the things that the court found last time. Court found that there was some evidence that they would have condemned. Numerous emails from the city officials and engineers saying, we need to get this purchased so we don't have to pay relocation benefits under condemnation. So, I mean, I don't think there's any doubt but what that's a question of fact that we're entitled to a finder of fact determine.
There's sort of an interesting legislative history following the passage of, I think it's HB 2032 that created this right to relocation benefits under the Eminent Domain Procedure Act. But then the following year, HB 2800 was introduced, and that bill would have amended 26508, the judicial review provision under the Eminent Domain Procedure Act, to specifically allow for review of relocation benefit determinations. And the testimony supporting that bill said that currently the statute doesn't provide an appeal right for that. And that was the justification for the bill, but that bill did not pass and the statute remained as is. Does that inform our analysis here at all in terms of the scope of judicial review under the EDPA?
I don't think so.
Because
I wasn't aware of that act being, that act being considered, or at least being proposed.
you would say we could just stick to the plain language and that right's there, and without an appeal right, it's rendered moot, essentially, if I understand your argument correct.
Argument is that the language was put in the statute under the Eminent Domain Procedure Act for a reason. And otherwise, it's just meaningless. And I don't think the legislature at least intends to prepare meaningless bills and pass them.
How is it meaningless? You still, I mean, you're saying you've got two avenues of recovery. You say you chose one. Why would it be meaningless if you only have one avenue, which is pretty process for the relocation?
If 26.518 had not been passed or placed in the statute in that in the Eminent Domain Procedure Act, there would only be one remedy, and that's fine. But obviously the legislature intended to have two avenues for getting relief. See, my time's up, and I will save the rest of my time for rebuttal.
Honor, may it please the court. I'm Shelley Starr with the city of Topeka. Thank you for the opportunity to discuss this case. Hopefully it'll be the last time. I'd like to draw your attention to a couple of themes in this case. The first one being statutory interpretation. A lot of words have been said and written about that in this case. However, plaintiffs control their cause of action, and plaintiffs clearly and consistently chose to proceed under the Eminent Domain Procedures Act. And the purpose of the Eminent Domain Procedures Act is much different than the Kansas Relocation Act. But plaintiffs chose not to proceed under the Kansas Relocation Act. And I think that a valid point has been raised because the Kansas Relocation Act provides an administrative remedy. And so by choosing to proceed under the Eminent Domain Procedures Act, plaintiffs chose to kind of backdoor and not allow a more administrative review of the process. And in all fairness, the decision whether to condemn or not to condemn is always the discretion of the city. And so to not be able to explore that in an administrative proceeding seems to me to be, this seems a little strong, but a little unfair in terms of how we work this out. Because now what the plaintiffs are wanting to do is take it to a jury trial. And a jury doesn't have the expertise or the background or the knowledge that the city would have to develop the record. And frankly, if you look at the Frick case, it shows that on review or on appeal, the the record that is reviewed is the record from the proceeding. So,
Let's back up a little bit. So again, this property was acquired without condemnation, but let's walk a hypothetical through, had you proceeded with condemnation. Statute, I think, plainly requires that city to condemn the property, you'd have had to name the owner of the property as well as any person who had an interest in the property, which would include those with those tenants with leasehold interest, okay? So now you're in a condemnation proceeding. How do those tenants get compensation for their leasehold interest for relocation?
they would have been notified, and I don't know that we have ever done that. I can't tell you policy reasons or whether that's a blanket rule. I don't know the answer to those questions, but to my knowledge, we have never done that. But the way I understand the procedure is they would get notice, and then we would have administrative proceeding and allow them an opportunity to present their claims to the city. And
Do they present it to the appraisers? I mean, the purpose of initiating the condemnation proceeding with the court is so that the court appoints neutral appraisers, permanent damages and compensation. Appraisers get to look at the relocation interests of the tenants in a typical condemnation.
no, and that the statute says that relocation benefits are not extra benefits. So the relocation benefits are statutory, and all of those would apply under the Uniform Relocation Act, or that's where they evolve, not based on the value of the property. Now, you're getting into way over my expertise in this area, so I don't know that I can specifically.
Then why would the legislature have created the relocation benefit right under the Eminent Domain Procedure Act if there's no vehicle for a displaced person to, exercise that statutory right?
My guess is that the legislature did not place it in that act. I believe the reviser did, and that is not indicative of legislative intent.
Does it serve the purpose of empowering, well, first of all, putting a standard in place, which is to look to the federal act, and if that benefit is there, then that's deemed fair and reasonable. And then second, to essentially give permission to move forward under subsection C to tell the condemner that you do have the power to negotiate with the displaced person for relocation. Is there any need, is there a need to have that, or what is, I guess even the purpose of subsection C that talks about nothing precluding negotiation?
So you're referring to.
I'm sorry, 26,518.
I don't know that I'm understanding your question.
Well, it just seems like if we're looking for a purpose for this to be here, is that purpose to do two things? One, just to set a standard that the federal policies that are equivalent are just our stamp. That's approved, that is a fair and reasonable relocation payment. And that happens under B, and then under C, it essentially empowers negotiation. Says while you're doing this condemnation action, you city or whoever the condemner is has the authority to negotiate with the displaced person for relocation benefits.
That makes sense. And also I would point out that chapter 58, the 3508 applies to the state agencies and political subdivisions, but there are other condemners out there. So how this applies to them, I'm not sure either, but there is hypothetically a reason for it. And that's really not the issue before the court today, but it's a fair question. And
Can I ask some questions about what is the issue here? Is it correct that your position is that the damages sought by the plaintiffs are fully awardable under the Relocation Act? I may be saying that wrong, but
under the Kansas Act,
yeah, under 58-3508.
I believe so, yes.
So we're really only
If-
fighting about procedure. The plaintiffs want to go straight to district court. You want to go to an administrative hearing. Is that the substance of this fight?
I believe so, yes.
Okay, so if that's the case, what is the benefit? Is there a legal benefit of going in front of a hearing officer? Or is it a sort of a pragmatic? In other words, do you get a more favorable legal standard or?
I don't,
Because eventually this ends up in a district court anyway, right?
yes,
And the statute says that it's a trial de novo.
yes.
So what's the difference? I guess that's what I'm probing at.
Well, the Frick case, the whole case was about whether trial de novo meant trial de novo or whether it was a new set of findings of fact and conclusions of law based on the record. So trial de novo, my understanding under the Kansas Relocation Act does not mean new witnesses come in and testify again.
So your desire or your hope is that the disputes of fact have to be resolved in front of a hearing officer. And then the reason the city's fighting this vigorously is because you think that's what the legislature intended. And then those facts would require deference from a district court reviewing that determination.
That's probably fair. I would say, though, that the reason the city is fighting this vigorously is because we never intended to condemn. And so now.
That's on the
just like-
merits. That's the
That's the
question.
merits, right?
But you
That's
filed the
not what's
motion for
before
summary
this.
judgment
Right.
on jurisdiction.
Right. And, but that is, I mean, just to say what the reason that the city is fighting this so vigorously. So I guess,
So just if you prevail here, let's say we just affirm the Court of Appeals, which entered a judgment that the dismissal be without prejudice, which would suggest that at least possibly this case isn't over.
right, so if the plaintiffs wanted to refile something within 6 months, their cause of action could still be alive, except if they want to file under the Kansas Relocation Act, their appeal time ran before they filed suit. So as Judge Klein pointed out in the Court of Appeals, their claim is stale under that act.
If they file under the Kansas Relocation Act and it goes to agency review, is that review constrained by the code of evidence?
Typically, in an administrative hearing, the evidentiary rules are relaxed, but usually that benefits the citizen much more than it would
Right,
the city.
But there are exceptions. I mean, some agencies are constrained by the evidentiary code. Do you know whether they would be in this instance?
The city does have an ordinance for administrative review. And I don't think it addresses evidence.
Can I ask you a question about the record? After summary, most recently, post remand back at the district court, after the summary judgment motion was granted, did the plaintiffs move orally to amend the complaint to add that claim under the KRA? And that was denied? Maybe that's not fair. I don't know that if you were there or not.
I was there and I did review that. They did move to amend their complaint, and I believe that was, I'm not sure if I know why they, or what their amendment would be, but
Okay.
I'm assuming
mean,
that's what it would have been.
I don't believe that there's not a challenge to that ruling, I don't believe, before us, but I was just wanting to clean that up from the record.
I have a question. Earlier, you said that the relocation benefits are included in the condemnation compensation. Is that what you said?
I might have said that. I'm not going to guarantee that's correct.
What is, I've just been looking very quickly, but is compensation defined in the E EDPA?
I don't believe it is.
Could compensation include relocation benefits?
It is specifically excluded, I believe. I can't give you the specific statute in front of me, but it is, I believe it's under the Relocation Act, and it specifically says that relocation benefits are not an additional element of compensation.
Right, so therefore it would be within compensation, correct?
I believe, like, so if the property owner, this is my understanding, so, but if the property owner is awarded in a condemnation, say $100,000, and the tenant's lease, that the value of their lease is $150,000, their lease could swallow up all of the owner's compensation. And that would happen in a situation where there's a really long-term lease and the values have gone up and up and up. There are a couple of cases in Kansas.
Right, but what about relocation? Could that swallow up too?
That I don't know for sure.
The reason I'm asking is because we have this very interesting statute that, you know, limits the scope of review to compensation. And if the relocation benefits are part of compensation, which is not defined, then you would have a right to appeal relocation benefits.
But compensation is for the taking of the property, and relocation benefits are statutory. They are not for the taking of. They are for.
But you just said that under the KRA anyway, that the relocation is not on top of compensation. Therefore, it must be part of compensation.
No, well, I said it's not an additional.
Right.
In eminent domain, it's not an additional benefit or an additional compensation. It's statutory. There are. My understanding is that relocation benefits they are extra and separate from what's awarded in.
Why are relocation benefits not compensation as contemplated by 26-508?
Because they're specifically excluded by statute under the Relocation Act as benefits, additional benefits in a condemnation.
But you just said they're not additional benefits. I'm getting confused.
That's because I'm confused, so.
Can I ask a related question, which might just heighten the confusion? I don't know. Let's just say there were no statutes at all that govern this. in order to condemn this property, do you know whether there's any case law that says the Constitution would require just and reasonable compensation for the relocation expenses?
There is nothing that says that to my knowledge.
One thing that's been bothering me is so 26-518 acted in 2003. It's basically says wasn't a condemnation, you know, regardless of whether there was a condemnation or not, we look to the federal program and whether there's federal funding involved. Displaced persons are going to be, you know, defined, and fair and reasonable relocation payments will be paid. That's 26-518. In 2004 is when the legislature enacts 58-3508, which also codifies the relocation benefits, right?
Yes.
How would, when we're in the year in between, 26-15's been enacted, but the other has not, how would how would 26-518 have been enforced? And the Chapter 58 law is not in place. Doesn't that have to be an obligation of the condemning authority? And seems to me that the Condemnation Procedure Act would have had to have been the mechanism. I don't know what else, where else a displaced person would go. You have any idea?
Well, if there's federal funding, then the Relocation Act would have
It says
applied.
whenever
but
federal funding's not involved, that's 26-518. I'm
Right.
just saying in that 1 year, how would a displaced person have enforced their statutory rights?
I have no idea. Well, I'll close up and just say that whether or not plaintiffs are displaced persons, whether they properly exhausted administrative remedies, or whether they have evidence to overcome the city's position that it would not have condemned this property had negotiations failed, plaintiffs should have proceeded under the more specific Kansas Relocation Act. And the city asks this court to affirm the district court and the Court of Appeals decisions dismissing this case for lack of subject matter jurisdiction. Thank you.
Hamilton, you reserve 3 minutes.
To answer Justice Biles' question a minute ago, actually, if there is a condemnation, tenants are named, and if the tenant has a lease that is valuable, they have a right to share in that compensation. For instance, let's say they have a lease that's a long-term lease, way below market. That lease has some value, and they would be compensated. But there's nothing in any statute that gives the tenant the right to get relocation benefits under the condemnation action. So,
Do you think condemnation are purely statutory, or do they have a constitutional hook?
relocation benefits,
Right.
they're purely statutory.
So when the word codified is tossed around in some of these discussions as if there's some pre-existing constitutional right that's being codified, but it's really being created by statute.
Correct.
I understand both parties to be essentially agreeing with that.
I think so, yes, sir.
And as
The-
an extension of that, do you agree that relocation benefits are not covered by 26-513?
Correct. Absolutely. And actually, 513, KSA 26-513 does in fact define compensation under B and C. If only a part of a tract, this is C, if only a part of a tract or interest is taken, the compensation and measure of damages is the difference between fair market value and the entire property or interest immediately before the taking and the value of that portion of the tract or interest remaining immediately after. And the same thing on a full taking. So compensation in that sense is defined.
Wait, so where were you? Subsection,
Okay, 513,
Right, I'm there.
B and C. Yes. I read C. Find what compensation and measure of damages. That's in the condemnation action itself. Tenants have, these were long time holdover tenants, as I recall, maybe 20 years apiece. And the leases had expired long ago. So they would have no interest in the condemnation case under any circumstance.
But what is the advantage in your view of proceeding or I should say it differently, what is the disadvantage in your view of proceeding under the Relocation Act?
Under 58, chapter
Yeah.
58.
Correct.
The disadvantage is that you go through an administrative process, and my experience with those is the agency appoints one of its own as a hearing officer and one of its own as the attorney, and you're going to district court anyway.
And then what happens in district court?
It's an appeal, de novo, but it is on the record. So what you have to do is make a good record at the administrative level. And the district court reviews that. I think Star is correct that you don't get to call new witnesses. The court.
But you would
decided
have
that.
an opportunity to create whatever record you wanted.
That's correct. But it's just an extra step in process. Look, in hindsight, I wished we'd have gone into that. We'd have avoided a lot of these problems.
Hamilton, I want to give you a chance to push back on what I'm thinking.
Okay.
My question about the timing of 26-518 and 58-3501, the 1 year gap, the way it looks to me is that 26-518 got passed by the legislature in 03. And it clearly provides for displaced persons to have some kind of a relocation benefit using the federal system as a model. And it looks to me like somebody figured out that if they don't enact another statute, they're going to be stuck in condemnation proceedings litigating these issues. And so that's why the next year 58-3508 gets passed to create the administrative proceeding. You see what I'm saying?
Yes.
What's wrong with that? That, in other words, the legislature saw that there might have been the path that you identify and closed it off in 2004 by specifying the administrative proceeding.
If that's what was intended, they should have repealed 26-518. They left that provision in. And your point is very well taken that an important one I should have brought up, that there was a year gap. This was the only remedy you had. That didn't mean it was shut off when they passed chapter 50. Thank you very much, Your Honors.
Thank you to both attorneys for your arguments in this matter today. We will take the case under advisement. With that, court is now adjourned.